Most of this is kind of general, but it's kind of like just open office hours. So whatever general questions you have about, LLC formation, hey, I'm going through this, when should I start thinking about intellectual property, things like that, by all means. So it's just kind of open. So whatever questions you all have, I'm happy to try to help answer and kind of point you in the right direction with particular legal resources.
Okay,
So,
very cool.
Yeah. Yeah. So whoever wants to go first.
Let me hand you my card.
Yeah, absolutely. Awesome. Oh, so you're an author?
I'm a tech guy.
Yeah.
I've been a tech guy forever.
Okay.
Obviously, I'm a
Yeah,
little
please.
older, so I got a book. And mostly at the moment, thinking through how to protect the IP and the
Okay.
business of the book.
Okay. Absolutely.
That sort of thing.
Okay.
Yeah.
So yeah, when it comes to books, copyright's going to be your best friend.
Right.
So obviously, you may already know this, but copyright has a beautiful, immediate effect. The moment you write a book, an article, blog, what have you, you're already going to have what we call common law copyright protection on that. So that means basically someone cannot reproduce that, distribute it, make derivative works. So think about like Harry Potter, right? J.K. Rowling wrote the books. Hollywood wanted to make the movies. The movies are derivative. They're derived from the books, the characters, the plots, the protagonists, etc. So in that scenario, they had to get permission from the author in order to create derivative work. So you enjoy all those particular, it doesn't have to be a movie. It could be if you want to do an audio book or you want to translate the book into another language, right? You're the exclusive owner of it. And if someone else does that without your authorization, you have a copyright claim against them. So copyright's going to be your main friend.
Right.
I encourage people to get registrations only because although you do have like a common law protection, the registration enhances your ability to enforce your copyright. So if you ever want to go to court, you have to have a registration. If you ever someone is selling your book fraudulently, someone made copies without your authorization, someone made an audio book and they're selling it on Audible or whatever, you're likely going to need a copyright registration in order to go get Amazon to take those down or whatever internet service provider. It helps you in a lot of ways when it comes to enforcing and stopping other people from using your copyrighted work. So, yeah.
And I don't want to hijack, and I didn't expect to speak with you today, but I do have a ton of questions.
Yeah, for sure.
If that's all right.
Yeah.
And first up,
Mm-hmm.
so the way that I'm based, and so I'm just going to lay out my thoughts and then.
Sure.
So I helped a friend do this about 5 years ago.
Okay.
So I'm remembering what the framework was, but basically what I have set up so far is a transaction LLC.
Okay.
Which will take all the money from Amazon,
Okay.
from YouTube,
Yeah.
from all the other sources that's going to flow into the transaction LLC.
Yeah.
And I have a transaction business account.
Sure. Yep.
And my basic idea there, and I'm going to do my best, my basic idea there is that that gives the place to sue if something goes wrong with any of the business deals,
Yeah.
separating it from the IP.
Yeah.
And since it's an LLC, if it goes wrong, all I got to do is just stop the money flow.
Yeah.
And 2 years later, poof, no one can touch anything to do with it. So that's my first.
Okay.
That's as far as I got so far.
Okay.
And because there may be other participants and creators. So let's say I do, and again, this is what's going on in my head.
Sure, absolutely.
So let's say I'm doing a series with another YouTube content producer.
Yeah.
And we want to do a revenue share.
Okay.
It would be through that bank account and that transaction LLC.
Okay.
That would cut the revenue deal with him.
Sure.
So if something goes wrong with him, it doesn't touch my IP.
Yeah. Yes.
Am I?
Yes.
I'm not
You're
crazy doing that.
No. You're thinking about it the right way. You need to switch up the mic, or
if anyone's talking, you can get this mic.
We'll hand it around. Yeah, that makes sense.
perfect. So the way you structure your company, like you mentioned, structuring your company can be done in a way so that you insulate certain assets from liability, right? Yeah. So to the extent you have, transactional, where at least one LLC does like the transactional work.
Right.
A lot of times you'll see other companies, they'll have IP holdings LLC. And that's literally where they store all their IP. Every application they file, whether it be a trademark, copyright, patent, etc., it's all filed under that IP holding. And it's all dependent on the company, what kind of tax liability you're willing to deal with, how you want to structure it. I always tell people there's no right way to set up a company and structure it. It's all dependent on how you want things to work. Sometimes people are more concerned about taxes. Some people are like, I don't really care about taxes. We get sued all the time. I want to insulate from liability. I like to use Google, for example. Google went through a restructuring years ago where they were a corporation, and then they broke themselves down into now they're Alphabet LLC. Now they're still in the corporation side that gets publicly traded, but a lot of them are broken down into, so you have like IP Holdings LLC, you have other things for like distributing certain assets. So that's the way they like to structure it, right? And that's their strategy, and they're comfortable with it because it works with their business model. So there's a lot to think about, but you're not crazy. I would say, so there isn't I would caution on the fact that, I do get that question a lot. Like, okay, if one of the LLCs gets sued, I could just take all the money out. You could do that. That may not necessarily stop them from still being able to come after whatever assets you may have.
Totally.
And that's typically through what we call, if they do get a judgment against you, enforcing the judgment. Sometimes they can reach into other places in order to get that. However, for the most part, generally, you're right. They're going to be, if it's a particular LLC that there's a contract and there's a breach of that contract, or has caused particular harm, and then someone brings a claim against that particular LLC, that business entity, then that's typically the party that's going to be liable, and you're generally going to be able to reach to those assets. Now, if you move those, right, that can be considered problematic. They likely can. There's things like you can pierce the corporate veil. So piercing the corporate veil is like, so let's use that for example. Your LLC, your distribution transactional company LLC, you get sued, and you're like, okay, I'm just going to take all the money out. You have to put that somewhere. If it's in your personal account or it's in one of these other accounts, I now have an argument that you're now commingling those funds, right? So now I can say, I'm making an argument that you're basically acting as the alter ego, and now I can pierce the corporate veil and say, I'm not just going after the LLC, I'm going after you, or I'm going after whatever, wherever you put the other money. I may be able to make that argument and still go get those assets.
That's interesting.
Yeah.
That would be the argument they'd make.
Exactly. Yeah. So it's not like a foolproof way of saying, okay, I just structured this, but it is a good way to try to limit liability. For example, if you're transactional, if you have a lot of valuable IP that's not really involved in the transactional side, then sure, you probably want to keep those apart and keep the IP holding company separate and apart. Put all of the applications and registrations in the IP holdings name versus then just in the general, right? And so again, there's no right way to do it. There are wrong ways, but it all depends on what kind of liability you're trying to avoid, as well as considering things like taxes, right? If you get a bunch of C corps, you're going to get taxed so crazy. But if you have a bunch of LLCs, you're going to go get the pass-through tax. Simple and clean. You may have to pay taxes on each of those LLCs individually, and that may change how you want to structure things depending on how big or small you want your tax bill. But again, that gives you, like I said, Google does it one way. You look at Apple, everybody has a different structure. There's no right way to do it, but there are wrong ways to do it. If you just put everything in one big entity, now it's like all those assets that are under that name may be liable. If you just use an example, if you house the IP with the transactional side, the transactional LLC, right? Let's say you do get sued, the transactional side gets sued, but let's say the assets won't cover the judgment. Well, now they can go after and try to, get. Sometimes they get a trust, and they say, okay, let's try to license or auction off the IP in order to pay off this judgment. And so that's a scenario where it's like, okay, I don't want the IP assets to be jeopardized whatsoever. Or whatever other assets you may be talking about. You may want to house that in something separate to give it a sense of insulation. And that's the reason why business entities work.
House it in a trust to give it better protection?
Sometimes what happens if there's a judgment and someone is trying to pay someone on that judgment, sometimes the courts, either through bankruptcy or some other mechanism, will institute a trustee. And a trustee is an individual that's like, okay, I need to govern to make sure things are being paid, this judgment's being paid, or these obligations are being met. And sometimes you're in a position where they can make the call on, well, this LLC has these other assets, so what we're going to do is, even though these assets really had nothing to do with this particular matter,
right.
you have the assets housed under this particular business entity.
Right.
We need to find a way to auction them off so we can get this judgment paid. So
Okay.
that's a scenario.
That
can
totally
happen.
makes sense. It
Yeah.
really does.
Yeah.
And so the basic plan with the, let's just call it the operating LLC,
Sure.
is to have it be transactional. Money flows in, money flows out. It doesn't own any other assets, and that the money, to set a precedent. I don't know if this is imaginary, but to set a precedent that on a regular basis, it's not like the money's going to build there and grow inside that bank account.
Yeah.
It's that it flows naturally out. And your point about, not having that transactional LLC own a bunch of stuff.
Yeah.
That then they can go get it.
Yeah, absolutely.
So then my second question, and thank you so
Yeah,
very much.
absolutely.
So my second question is, when we're talking about globally protecting the IP, but the IP of the book, I haven't formed that LLC yet.
Okay.
And it will probably be called Gentleman's Almanac LLC rather than saying Holdings or IP.
Okay.
It'll probably be that.
Sure.
And so there's a specific question, then everything else gets foggy after that. So the specific question is, my name is Peter Roy Sorensen, but the book is authored by Peter Roy.
Okay.
And so that means there's a question of, what do I have as a copyright on the book? Because I don't want to have it copyright Peter Roy Sorensen. So it sounds like logically you have it copyrighted by the Gentleman's Almanac LLC.
So this is a good question. So
Yeah.
copyright, you can only get copyright from human created works. So
Right.
To the extent that you want a copyright registration, you are going to have to give your name. However, what you can do is you can assign it to the LLC. So there will be a function where you do have to identify, okay, with the Copyright Office, okay, this was authored by, your full name.
Right.
And then what you can do is, once that happens, you can also, even concurrently with the registration, you can say this has been assigned to, you can execute an assignment agreement where basically you sign it, and then you, as over the LLC, also sign it, and you execute, and then you record that with the Copyright Office, and now you have an assignment. So whenever you go look at that registration, you now see, okay, this is actually owned, the copyright is owned by the LLC, but it has a human author who is you. So you do have to prove that up. That's a big debate now we have nowadays about like artificial intelligence. And there was a case years ago, this monkey called Naruto at a monkey sanctuary. He grabbed someone's cell phone and he took a selfie. And you probably read about it.
Yeah,
and so PETA came and said, oh, like you need to protect the copyright in the monkey. The monkey has copyright. And the Ninth Circuit said, no, only humans get copyright. So you will have to disclose, like, a human did write this, right?
I'm
disclose
cool
your name,
with that.
right? But yeah, having it in the name, you can absolutely
Never heard
assign
that before.
it. You can absolutely assign it. Yeah, and that's with any IP.
That's really
any IP. You'll see that even with inventors, right?
Yeah.
There's an
Yeah,
inventor
it's
who
fascinating.
creates an actual device, right? And this, like think about Disney, right? Disney owns all this IP, but like the corporation Disney is a fictional entity that we just all form under the law, and that we all just socially construct and recognize. Walt Disney, the folks at Pixar, they came up with these characters, right? Those are human beings, and then it gets assigned back to Disney. So that's a function that's a function of it. But you can assign that just like with any IP, is just like any other asset. You can assign it, you can hand it over, just like you can just like you can with other assets. You can assign it over to someone. You can license it out where you keep the rights, but you license it out to someone. Like, think about just using Harry Potter, for example, again. J.K. Rowling, she licensed out the rights to Harry Potter to the Hollywood studios so they can make derivative works based upon her copyrighted works in her books. So that's an example. So if there's
That's
another
fascinating.
chair, you can feel free to bring it up here so you don't have to stand if you don't. I think, there's some chairs over here. No, feel free.
No, that's really fascinating.
Yeah.
Can I say something? Have you
Yeah.
heard of authentic artists?
Authentic artists.
Yeah.
I have not.
So it's an AI that generates music. There's
Okay.
music generated by AI. So I feel like based on what you're saying is none of that music can be copyrighted.
That's So and that is what we're generally, yes. If it's completely generated, completely created by artificial intelligence, the answer to that question is there is no copyright protection. Meaning anyone can use it and exploit it. Right.
Everybody can have the same idea. So,
Yeah, and it's not. You have to show there's human intervention. So the latest case on this was going back to a book example.
Yeah.
The Thaler case, I think is the name. Thaler case. It basically was this author. She wrote a book. She used artificial intelligence to generate several images in the book. And then she got a copyright registration. Shortly after she got the registration, she was on social media talking about, hey, my book, who has all these AI generated images, just got copyright registration. Copyright office got wind of it, clawed the registration back, and demanded, hey, you need to prove up to us what was actually created by human being and what was actually created by AI, artificial intelligence. Basically what the Copyright Office did is they carved out the solely AI generated works. So she has copyright registration on the book, except for those aspects that were only created by artificial intelligence.
Wow.
So
That's fascinating.
they challenged it.
I didn't know
They
that.
challenged it in district court. District court ruled in favor of the Copyright Office. It went up to the Court of Appeals. They also ruled in favor, and then they tried to get cert for the Supreme Court, and the Supreme Court denied cert. So the Supreme Court won't hear it. They're going to let that decision stay. So that's the law right now. Now we're grappling on whether that should be the case or not. But I think the big issue is that's one of the big issues with artificial intelligence is this. If it's completely created by AI, the rule is there's no copyright protection, meaning anyone can use it. So I had this conversation with so my background is in computer science. I was an IT, information technology professional before law school, did a lot of programming. And so I was having this discussion with programmers, and they were like having the concern with they're having a debate about, should we allow programmers to, because now you can just go on ChatGPT, you can go on Bard and be like, hey, draft me code in C++ or Pascal or JavaScript that does X, Y, Z. And it's like, now it's like a question on the value of certain programmers because they can just easily go and it can spit you out a script that you can go and revise, and you don't really necessarily need all the background. And I told them, I said, I don't necessarily think that's true, because if I as a human being code something and actually, prepare source code, there's copyright protection. So that means if someone else, and if I'm employing them, then as an employer, through what we call the doctrine of work for hire, I am the owner of that. So there's a doctrine called work for hire where if you're an employee and you create something in the scope of your employment, even though you as a human being, the employee created it, the employer owns the IP, owns the copyright, I should say.
And that's what made Disney famous.
Yes, exactly.
It wasn't Walt that came up with all these characters.
Right.
It was his employees.
Exactly, his employees, and that all reverts back to the employer. So
kinda
they
see
have a
that
claim.
all around us, though, right?
Oh, yeah.
Like with Apple.
Oh yeah,
Yep.
everywhere.
Yeah,
Especially
absolutely.
in technology, in semiconductor industry.
Absolutely.
Because like when I look at all of what's happening right now, like we talk about AI, right, and fascinating ChatGPT and stuff like that. There's only 3 companies that own all that. And to me, like when you ask a question and it spits out code to you, basically you're allowing those 3 companies to understand which way an industry is going.
Oh
Yeah.
yeah.
So if they see that there's more questions being asked this way, then that's the way that they're going to develop.
Yep.
Yeah, it's like
Yeah.
insider knowledge, right?
Yeah.
And then, which is like nothing wrong with that, but that's part of the reason why I enjoy like just kind of hearing
Yeah. No,
your
absolutely.
perspective on that, because then like it kind of not really so much muddies the waters, but like just like you said, like okay, this developer works for another company, asks a question, that company owns the IP for what that developer was thinking, right? However, Microsoft knows all of it.
Yeah.
So they, this one entity may develop that and have that IP. However, Microsoft still has it, or Google, or what they have it.
And I'll just add on top of that, you got to layer in the copyright. So in that scenario, I develop code, but I use ChatGPT or Bard to do so, right? Now, if a human being coded it, there would be copyright that would vest either directly with the coder or if they're employed with their employer. When you develop it by code, there's no copyright protection. So that means anyone can take that code and go copy it. And basically, if you develop an app using ChatGPT, now if I get a copy of your code, whereas normally if a human being coded it, you'd have a claim for copyright infringement and be able to go after him and stop him. Now, if in that scenario you copy someone's code that they generated solely with artificial intelligence, even if they made some tweaks to it, the parts that were, you really need to recode a substantial part of it to show that there's been actual human interaction and human development of the source code. But if you're by that point, it's like, well, you might as well just coded it from scratch at that point. The purpose of ChatGPT is you may make a couple changes here and there. Aside from those small changes, the rest of the code is not going to be subject to copyright protection. So that's a big thing that you lose. And that's what I was telling the gentleman that we're talking about that. I said, I think that's the big issue is you don't want people coding that because you lose out on all the IP rights. And that's part of the value. That's what gives it value is that, hey, we developed this. No one else can go and just copy this code and then just integrate it into their source code.
What is the main reason behind not allowing AI to copyright something?
So, I mean, there's a lot of things. So there's a lot of, number one, it's the precedent that only human beings, only human created works can be provided source code. So on one hand, there's like a slippery slope because if you do start allowing artificial intelligence, number one is like who owns the copyright? Is it the person who developed the code? Is it the person who used the artificial intelligence to develop it? Is it the code itself, which some people argue and I don't really completely understand? So there's that question of who gets it. Is there a joint ownership? Do you split ownership? Who gets a share? There's all different kind of stakeholders, so it gets questionable. Same thing like we use like the monkey example I used before. The monkey grabs his cell phone, takes a selfie. Who owns it? Does the monkey do that? And then who can, a monkey can't go file a lawsuit and enforce it.
Or
so it's like
how he wants to spend his royalties.
Right, exactly. So like who,
He's
PETA,
probably just going to say bananas.
Exactly. So even going back to that case, PETA brought that lawsuit on behalf of that monkey, and there was a big, aside from the fact that the monkey couldn't have copyright, there was a whole separate argument on does PETA even have standing to even bring this on behalf of this this animal. So there's like that big question, and I think they put it aside because they said we don't even need to get to that because there's no copyright period here, so there is no claim to be made. But that's part of it. There's a lot of arguments. There are people who are on the side of okay, AI works, do need to have there's some level of creativity depending on right. I disagree. I think like if you type something in the ChatGPT and you're like, hey, spit out code. I don't see any kind of creative element there. Now, maybe if you're like there's other forms of artificial intelligence where you're like, hey, take these images and put them together. There's arguable that you're using a tool. Some people argue it's no different than if I use like Canva, right, to create a flyer, right? I didn't really generate all those and create all those, chevrons and designs. Who should get copyright protection in that scenario on a flyer or a logo that you create? You're using a machine in order to develop something. So there's an argument that it's being used that way, but I think that's a little different.
I heard that Microsoft Word, like if you create anything on Microsoft Word, they actually own.
Oh.
If you read the terms, if you read the terms of use and service, I haven't read them, but that probably sounds right.
Yeah.
Or at least have a license to it. It probably depends on, it's just like Instagram, right? If you go read the terms, I can't opine on Microsoft, but I'll use Instagram, for example.
That's fucking
Instagram,
bonkers, though.
Yeah,
because you're not an employee of Microsoft.
Right, but
you're a customer.
But that terms of service that no one reads, but I do because I'm an attorney. When you open up an account, like just use Instagram, and I can't opine on Microsoft because I haven't read it, but it wouldn't surprise me if there's at least like a license. If you create something with using a Microsoft product that they have, it likely isn't a ownership because they'd have to get an assignment, and assignments have to be in writing. I mean, there needs to be an agreement that we all come together and we actually execute. A license doesn't have to be in writing. You don't have to have that formal, here's a contract. So like Instagram, for example, or TikTok or any like Facebook as well, those terms of services, any photo or content that you upload, you're giving them a license to use that content. So if Instagram ever, you see an ad and you're like, oh my God, that's a picture of me that I posted like last year when I was in Hawaii, right? Why is it on there? And you ever go challenge it, they'd be like, well, when you open this account, you check the box that you read all the terms of service, and in that terms of service says that you give us a sub-licensable license, worldwide, irrevocable license to use this particular work. So in that scenario, you're giving them a license. Now, a license doesn't mean that you lose the rights completely. You still have the copyright, but you're giving them permission to use it. So that's scenarios where you see if you don't read the terms of service and use, well, there's likely a license.
Never knew that.
I don't necessarily. I would doubt that there's a real ownership like an assignment, because typically that needs to be in writing. You need to have something that's like, we really sat down together and I contemplated giving you all of my IP rights. The law is only going to recognize a contract when it's actually physically in writing, typically with signatures. So there's no terms of service. When the terms of use is kind of just like you're agreeing to this. If you're going to use our site, you're going to agree to this. Technically, it is in writing, but likely it's not going to be enough to be enforceable. You need something a little bit more.
It's kind of like what they did with Visual Studio. Like for the longest time, Visual Studio for Mac was a terrible project. Like nobody could install Visual Studio on Mac. The minute that they went and they made it open source, like they open sourced the code, then all of a sudden Visual Studio just became amazing, because you had all this, like the open source community dove in and they fixed the product for Microsoft. So in a lot of ways, it was just like an opportunity for them to capitalize on people who were using the product anyway, but it's still their IP. So they own this product now, and they gave it away for free, but it's kind of like the illusion of open source, because then they can take something and kind of make it closed source too, because like I think it was about 2 months ago, Terraform project.
Yeah.
A bee?
I think it was
A fly?
fly.
Okay,
yeah.
cool. I'm just
I'd be
allergic
the
to
same
bees,
way.
so I don't want to get stung. I don't want to swell up in front of you guys.
With an EpiPen.
Yeah, right?
Terraform had their project open source, very, very widely used throughout the community. I'm a platform engineer, and we rely heavily on that. And what happened is that license went from open source to closed source, and it disrupted so many different projects, across so like now, it's like, we went from using this tool that was free open source to now it's like we have to rethink our entire infrastructure.
I think it's happening right now, like the announcements with ChatGPT last week, where they're going to stop having their current plugin APIs working and move it over to an app store. Is that bringing it to more closed source? Is this going to disrupt? It's going to blow up all of the.
That happened
So
with
that's
Reddit.
all happening.
That was that big thing with Reddit when they closed their APIs. It was like now all these businesses are like, wait a minute, I can't do my business anymore because I was dependent on that API. And
So you triggered a thought that I wanted to present. So I went to a meetup last week, hosted by Southwest Gas of all things.
Okay.
It was a real meetup.
Yeah.
And they had like 6 of their data security people there, and it was really the person that was running it was amazing, and they kind of wanted to get other thoughts. So in that meeting, they talked a lot about issues related to AI and attacks. But the main thing they talked about was, do we want our employees using any form of AI? Because the external providers get to know all of our business and all of our data.
Yeah.
So as part of the meeting, which I thought this would be impossible, one of the engineers in front of us very easily chose one of the open source available GPT language engines, created a vector-based database, and used an app that's easily available to create his own separate large language model on a laptop that no one else in the world could see or get to.
Yeah.
So part of what he wanted to do, this guy was really crazy, was show people how actually it's not rocket science to protect your data, and that we are kind of in the beginning stages of the Wild West to put all your code in your own spot and have your own AI run on it.
Yeah.
I was like,
Yeah, I think
it's like, Because
these,
then you get to keep copyright because
yeah,
it's yours.
absolutely.
Maybe.
I think one of the big concerns that aligns with that is, if you have, I do not, it doesn't surprise me that Southwest Gas would say something like that, because you're right. You know, if you type in information into ChatGPT, right, if you go read those terms and conditions, they are storing all of those prompts, all the information, and this is also dovetailed over into like data privacy, cybersecurity concerns,
Yes.
trade secrets.
Yes.
Right? If you are putting personal identifiable information or using kind of AI, PII or trade secret information, right? That may give away. So trade secrets are like, your secret sauce. Like think about, the Coca-Cola formula, right?
Right.
Coca-Cola formula, it has trade secret value, right? If someone, the CFO leaves and wants to go work at Pepsi, and he wants to take the Coca-Cola formula over to Pepsi, right? They can sue him for trade secret misappropriation. They keep it a secret. They don't publish it. It has value as long as it remains a secret. But if you put that into a AI model, there's an argument that now you've disclosed it, and now that information has been gone. So if you have employees that have access to trade secrets, and they're like, I wonder if there's a better way for us to, let me drop this, we develop Coke when we're at this altitude, with this amount of pressure. Let me use ChatGPT to come up with some other calculations, and you expose some of those trade secrets. Now you have an argument that it's been exposed, and now you don't have trade secrets, but also personal identifiable information, protectable data. You have information on someone's name, their email address, their username. If you're using artificial intelligence that's in like a public subsidiary like a ChatGPT or a Bard, right? They're collecting that information and they're letting you know in the terms like, we're going to use this information. Now you're in a situation where that information may be exposed and you may inadvertently be breaching and violating, and not be in compliance with specific state and international data privacy laws. Because now you've without authorization, you've exposed certain PII. So that's a concern as well. And then to the extent ChatGPT reads that information, uses it, and spits it out for other prompts, now you have different forms of breaches. So
For
there's
other people's
things being
inquiries.
exactly. So it becomes a recursive issue that can turn into other things. And then one more thing I'll say also on the copyright side. The other thing too is that you also see this. Remember, I talked about derivative works that are derived from others.
Yes.
So let's say, for example, there's a lot of these artificial intelligence models that spit you out images. But where are they getting? How are they spitting out these images? Well, they're looking at other images.
Of course.
Right.
You have to, right?
And but who owns those other images? If those other images are subject to copyright protection, there's an argument that what it's spitting out is now an unauthorized derivative work.
Man, maybe that's why maybe that's why AI isn't supposed to be allowed to do this, because essentially AI is taking from everything.
Yeah.
Either bits and pieces or
Yeah.
chunks.
Yep. All the data scraping, like unless you have a way of really understanding if the data that you're scraping is either personal identifiable information, copyright protected, or has some other kind of protection on it, you just incorporate that into AI model, which is the whole purpose of artificial intelligence, is to be able to just use mass amount of data and then process it and give you good output that's consistent with what you're looking for. But in this scenario, I think there's a hurdle there because you could be in a position where it's either considered an unauthorized or it's just a straight direct violation. By collecting the information, collecting that image, it could be argued that it's a distribution or reproduction of the image without authorization. You don't have to necessarily go through the whole derivative use issue. You could just be plainly, this is a straight copyright infringement because you use this image without our permission. And you could argue it falls under whether it's like reproduction, distribution, public display, or even what we call public performance, right? Like, and that generally comes up like when we're talking about like songs. Like I write a song, right? I wrote that, but someone gets up and publicly sings it. That's a public performance. Even though I'm not necessarily reproducing, I am in a way reproducing it, but in a way, the image you could argue is actually being performed by running it through this particular AI model. It's at least an argument. So I think it opens up for more liability there, and it's something I think people need to consider before. And this is even whether or not you're the artificial intelligence company or if you're the user, right? If you're the user and you're like, oh, I'm just going to go on Google and grab these 10 images and then input them into this AI and say, hey, spit me out an image based upon these, right? Me in that situation, I'm pulling these images without authorization and I'm putting them into this artificial intelligence model. Me as the user on the other end also may have some liability as well.
That's the machine learning part, as far as like how, because from how I understand AI is that AI is dependent on machine learning. So wherever it's getting its data from, that's what it's training against, and that's how it knows how to identify.
Yeah.
So if there's corrupt data in there, then it's going to train against the wrong models. And now I don't know.
Bad data in, bad data out. Infringing data in, infringing data out. So
that just sounds like Twitter.
Yeah, well, yeah. Basically.
It's like you're raising a kid to be biased.
Exactly.
If the kid doesn't, I'm like, I don't know. The kid's he's always been that way.
Yeah.
So.
Yeah, so those are some of the main concerns with artificial intelligence as it stands now that we're seeing.
Kind of a two-part question. Yeah. Have you heard of Coca-Cola Y3000?
No, I haven't.
It's a new flavor created with the help of artificial intelligence.
Oh wow!
So I guess that was the first question. The second question is, like, you touched on it earlier with the coding and how you need to substantially alter it. Mm-hmm. Like, what does that mean exactly? I'm sure there's gray area, but like substantially alter it by X amount percent. Yeah.
So on the first thing, what Coca-Cola, I don't know. They say they generate with artificial intelligence. I don't know how they did. I need to understand what they may have. I'm sure they use like some internal. I'm sure they didn't just go on ChatGPT and be like, hey, what's a new flavor? But they may have used some internal tools, artificial intelligence tools. We're probably fine, right? And in that situation, again, there's different areas of IP, right? I tossed out copyright. Sure, you're not going to get copyright. There's nothing to say that that's not necessarily a trade secret, though, right? Okay. Trade secret. Right. There's not necessarily a human element, just like with trademarks, right? If you went to ChatGPT and said, hey, spit me out a couple interesting, like, unique names for my business, and it spit out some new names, and you're like, oh wow, that's a really good name, or that's a really nice logo. To the extent there's no copyright issues with the logo, but with the name, right, there's no like requirement that it has to be developed. It just has to be used in commerce to distinguish goods and services. So if like the people who came up with Nike, I don't know their story, I don't know the background, but let's just say, yeah, they just like popped it into, say Nike didn't exist. And then like today they're like, ChatGPT, give us like an interesting name for like a shoe, an apparel line for athletic wear. And then they were like Nike. And be like, oh, okay, great. As soon as they start using it in commerce, no one's gonna be like, oh, AI created this. AI is pretty much, it gets usurped when you try to exercise copyright. And then also when it comes to patents in some cases, where artificial intelligence can be helpful, but there has to be a human inventor. So it has to be a human author or human inventor to get patent and copyright. However, with like trade secrets, trademarks, those areas, there's not necessarily a human requirement. So to the extent they used it, there probably is trade secret protection. Any output that was created by the artificial intelligence probably isn't copyrightable. But to the extent they use it just to develop like internally, there still may be some IP protection, just not like copyright. To your second question on, remind me your second question.
Like again. The percentage substantially altering something?
Yes. So there is one of the big myths is like people talk about like fair use when it comes to copyright. Oh, like if you change it X amount percent. There is no bright line rule. So fair use there's four main factors that we look at. We look at how much of the work did you use, and not just the substance of use is not just how much, but it does go to the heart of the work. So take for example like a UFC fight, right? Let's say the UFC fight. Let's just say like the actual fight goes, and this may be completely a super long fight, but like 10 minutes. Let's just say the clip is 10 minutes. Okay, but the knockout is only 10 seconds. Mm-hmm. So if you go and you copy that 10-second part of the knockout, yeah, it's only 10 seconds and it's only a very small percentage, but it's the very heart of the whole fight. That's what everybody wants to see. Everybody wants to know, if you go 12 rounds in a boxing match, you know, that 10-second clip of the knockout is what everyone wants to see. That's the heart of the work. It's just like if I, using, for example, let's say if I copied a book, right? But let's say there's like 40 pages for the appendix where you just cite all your sources and whatnot. Let's say I copy all of that. Yeah, I copied a lot of it. 40 pages is probably a large sum. However, it may not necessarily be the heart of the work. So that's a scenario where, yeah, I copied a lot of it, but it doesn't really go towards the heart of the work. So that may favor not favor fair use. Whereas even though I copied that 10-second clip of a 12-round fight, even though that's such a small percentage, that may still go against and be like, that's still not going to be fair use. Other things we look at is the purpose and character of the work. Also, is it going to be, are you using it for commercial purposes or not? Right? Now, that's not dispositive. That's only one. So a lot of people say, well, I'm using it for a nonprofit. I'm using it for educational, so I'm okay. Not necessarily, right? There's still 3 other factors you need to look at. So and this actually came up with Google and Oracle. There was a big battle because Google had copied a lot of Oracle, and I think it was like it was a lot of lines. It was several thousand lines of code, but only amounted to like 3% of Oracle's entire API or source code package. And so the court ended up trying to wrangle with that and had to deal with it. And they ended up finding in favor of fair use in that case. But it's a mixed question of law and fact, and even the courts disagree. So the Supreme Court has had to address a lot of fair use issues because you have, our courts are in different circuits. So like we're the 9th Circuit. If you go to Texas, you're in the 5th Circuit. If you go to Michigan, you're in the 6th Circuit. If you go to Florida, you're in the 11th. If you're in New York, you're in the 2nd. All those circuit courts can come up with can take, distinguishing paths on what's fair use or not. So courts can disagree on whether or not something's fair use or not, and sometimes we have to wait and beg for the Supreme Court. And even the Supreme Court just earlier this year, for years they had been recognizing that, I'm not sure if you all followed that Prince case. So there's a case, so let me just back up. There's the Warhol, Andy Warhol, he used to make kind of these imitation images, and he used to rely on this doctrine of fair use that if I change it enough so that the purpose and character of the use is different or it has a different message, right, then it's considered to be fair use. That first factor, purpose and character of the use, weighs in my favor. And that kind of dictates the rest of the analysis. He used to rely on that a lot. And the courts for years, including in the Google and Oracle case, were like, yeah, the messaging, once you take the work and you change it enough where the message is different, it conveys a different message, well, yeah, that's going to weigh in favor of fair use. Well, in the Warhol case that they decided, now, I believe the Google Oracle case was in 2021 or 2022, so not that long ago, where they said, yes, changing the message, it conveys a different message. Okay, yes, likely it's going to weigh in favor of fair use. In this case, the Warhol case, basically Andy Warhol, there was this photographer who took pictures of Prince before he got big, right? And they had these photos and they kind of commissioned them. They licensed them to Vanity Fair, another company. That company then went to Andy Warhol and said, hey, we have these images. Please, we want you to make up some imitation images. So he did. He made up this one orange one that kind of took the Prince image, but distorted it a little bit, added a lot of different colors and hues, and made it kind of it looks like an Andy Warhol piece. So the photographer did not know about this. They did not authorize Andy Warhol to make those images. They just gave a non-sub-licensable license to Vanity Fair, whoever. So then Vanity Fair used that image. The photographer has no knowledge. Fast forward to 2016 when Prince dies. Prince passes away. Vanity Fair is like, we need to do a new issue that commemorates his life. Let's use one of these Warhol images that he created years and years ago. So they put that on the cover. Photographer finds out about it as soon as it's on the cover of Vanity Fair. It's like, that's my image. They didn't have permission. Who created this? Andy Warhol did. So the photographer brings lawsuit against Andy Warhol, and they argue fair use. And it bats and forth in the trial court, goes up circuit court. Supreme Court then says, hey, look, I know you guys have been relying on like this conveys a different meaning, but we also have to look at like what are like the commercial impacts and direction of the work of the authors here. And the court ended up going back on all this precedent on conveying a different meaning and making it transformative. Conveying a different meaning doesn't necessarily make it transformative enough for it to be fair use. So I bring all that to say the courts even disagree. And also, one big key thing about the Supreme Court is Justice Breyer was really seen as the IP expert on the Supreme Court.
In Texas?
What's that?
In Texas?
No, he was on the Supreme Court.
But
So
isn't like the district in Texas, the Supreme Court, don't they handle like most of the IP stuff in the country?
So the Western District of Texas, you're thinking about Judge Albright. He does a lot of patent. He has a rocket docket for patent issues. So just a quick tangent on that. When you want to litigate a patent, typically what happens is there is something called a marksman hearing. And this is when the court comes together and they kind of determine what the terms and claims of a patent mean. And it kind of dictates where it's going to go. But it takes such a long period of time that when you're in a patent litigation, if you're the one being sued, what you can do is you can go and say to the USPTO, this patent needs to be re-examined. And once that happens, typically what happens is once you get, and it takes some time, because the Markman hearings take so long and patent litigation takes so long, you can get those re-examined. And then what happens is the patent litigation gets stayed. And then it allows the USPTO to go re-examine it. And you basically have to go through this, basically the same process of how you got your patent before. And then after that's done, then you can go back to the district court and say, hey, let's continue the patent litigation. In a rocket docket like Judge Albright, where he invites people to come file in his court, he says, I'll get you through a Markman quick so that you don't have time to go through a re-examination.
For a fee?
No, well, not for a fee. He's not paying. He just wants people to come down there. He's just a big patent guy. He was a magistrate judge, and then he became an actual full-time judge. I should say full-time judge, but a full district court judge. He invites people to do it, and it gets to, I've actually practiced in front of Judge Albright. Last summer, we had a trial in front of him down in Waco. We ended up settling right before we had closing arguments right on the courthouse steps. It was an interesting case, but that's a scenario where it's not necessarily IP, but he does a lot of people will file there. Also, the Western District incorporates Austin, Texas. So with the new rules, now that's kind of becoming Silicon Valley Part 2, when there's a lot of lawsuits that that you can get jurisdiction and venue in the Western District of Texas because it capitalizes on what. So if you are headquartered or formed, have your principal place of business in Austin, Texas, that's why you can get people and actually challenge them there. On the bigger question, Justice Breyer on the Supreme Court, he was on the Supreme Court. He was really the expert on copyright law and even trademarks. Not so much patents, but copyright and trademarks. He was like the expert. He did a really good job on, even when he would dissent and the court would go a different way. All the IP practitioners, a lot of us would be like, Justice Breyer has the right idea when it comes to IP. He retired, and Justice Ketanji Brown Jackson is now in his place. So we don't have that jurisprudence from Justice Breyer. So now we're kind of in a new era, the post-Breyer era. So it makes and so this also makes sense, right? Where you have a decision during the Breyer era where we acknowledge this conveying a separate, this transformative nature that goes in favor of fair use. And now as soon as Justice Breyer's off the bench, you have a unanimous decision from the Supreme Court that says, hey, no, we're going to do away with this old precedential decision on what makes something transformative and when fair use is going to apply. So that's a big thing to keep in mind.
He was the blocker. He was the one that kind of stopped.
Yeah, he helped guide the court as well. Like, the Supreme Court is not necessarily just Justice Breyer says this is right on IP, that's the way it's going to go. But he was definitely a very strong voice. And even when he was wrong, his dissents were still really strong, and he could help reason, right? And so my big thing was not saying whether or not the Supreme Court's going to be right or wrong moving forward, but it's important for us to recognize that the law may change because the Supreme Court may be settling these things differently now that we're in a post-Justice Breyer era versus before when Justice Breyer was there to kind of influence the court and provide his expertise on this area.
Do you feel that when he was there, he did a lot of things to kind of protect
Oh yeah,
those things? And
I think he did a good job. Yeah.
I'm always kind of not fearful of that, but I don't like when everybody's unanimous because that's not good.
Yeah, it's no, fair enough. I think it's a. I mean, sometimes the court it comes down unanimously, and I think I wouldn't necessarily say it's not good, but it gives you an indication on when there's a 9-0 decision, right? That's a really strong decision if you're on the winning side. It's like none of the justices. There was not one person that even it wasn't even a plurality where they're like, I'm not dissenting, but I'm also not joining with the majority. Everyone said we're joining with the majority opinion. There's a couple like concurring opinions that added just like a little extra decision. But it gives like some insight, like the court really wasn't wavered one way or the other. So those are some things to keep in mind. Forgive my yawn. Those are some things to keep in mind that the law can change, especially when it comes to copyright. I'm not saying it's going to make a big sway, but it's something to keep in mind that decisions may be different. But that goes to your question about fair use. There is no bright line rule. Where the line on, I shouldn't say a line, but where something's going to kind of fall in the world of fair use, whether or not code is changed enough, is a mixed question of law and fact. And it's largely going to depend upon even including what district you're in and what state the Supreme Court is in and what decisions they made on the actual issue. So there's no taking a particular work, whether it's like source code that was generated by artificial intelligence or someone else, changing it just a certain degree isn't going to be enough to tell you if it's going to be fair use or not. It's a whole factor. We need to look at all of the context. How are you using it? Is it commercialized or not? Is what you're changing go to the heart of the particular work or not? Does it change the meaning enough, right, for it to be, does it meet this new definition of transformative? All those have to be considered. It's not just like, well, I changed it enough, I changed it 20%, 30%, 90%, right? That still may not be enough to get you out of copyright infringement liability.
Cool, thank you.
Yeah. Sorry, I know that was a little long-winded, but I wanted to kind of bring it all together.
You gave a lot of context.
Yeah.
Substantiate.
Yeah, I don't just want to sit up here and tell you, I'm a lawyer, this is what it is. I like to be able to use like examples so that you can be like, oh wow, like when you look at other examples in the world and you're like, oh, okay, that's a great example. Like, okay, I see that's how that works.
Well, I have a question about AI.
Yeah.
Pertaining to the fact that, like, okay, there have been different things that have happened when, like, say for instance, somebody lives in a state where there's abortion, right?
Yeah.
And a young lady says, abortion clinics near me. I've heard cases where that person can be brought up on charges just for doing that search. So my question is, like, for artificial intelligence, are there certain things that you shouldn't ask it, to kind of avoid getting into a scenario of hot water that you didn't really anticipate? Yeah,
I think it's going to depend on the context. Like, I'm not too familiar with that. Like, I've heard a little bit, but I'm not entirely sure. I can't opine like on that particular hypothetical, like on the abortion, like how far they can reach. I will say this: it's important to understand how artificial intelligence models work. It's easy and fun to say, oh, AI, artificial intelligence. It's a great buzzword to toss around. But honestly, I found a lot of cases, like some people are saying artificial intelligence, and I'm like, there's no artificial intelligence actually involved here. You just have a source code. You just have an app, right? Show me the artificial intelligence. I had a client. I was like, okay, like, I have some concerns. Like, explain this to me. They're like, yeah, we use AI to do blah, blah, blah. I said, okay, like, what artificial intelligence are you using? Well, it's like, well, our code, the computer just reads it and then, it operates. I said, okay, but how is that artificial intelligence? It sounds, yes. It's like, it sounds like it's just a normal computer to me. I was like, don't just say it's artificial intelligence. And you should be able to explain it to me. Right, machine learning, it uses this, it's able to compartmentalize this and spit out by using a database of information, it's able to spit out certain output, and using that in a recursive manner. That's generally what you're talking about, and they were not using it that way. So I wouldn't use that. I think it's important to understand how it's used, and also who has access to it, right? In a lot of settings, right now, let's use that for example. If there is you provide any kind of information to anybody, whether it's AI or any other company, there's always going to be some level of risk that if the government comes knocking on the door and they subpoena and say, hey, we want this information, right? They likely have access to get, and that you may not have an excuse unless there's some other constitutional or what they're asking for is too broad or not relevant. Aside from that, they will likely be able to pass it up. Now that doesn't necessarily mean there's like this auto reporting. There needs to be some kind of case in controversy, a lawsuit, criminal complaint filed for them to be able to get that subpoena power. But that's something to keep in mind. Like if I am a company and I'm gathering data and then the government comes in and says, hey, like, John Doe who lives at such and such street, we understand that he's on your app and we need information concerning, crimes, fraud he's been committing using like this app, right? Me in that scenario, I may not have any choice but to give over that information because I'm compelled to by the government. So I don't necessarily think it's a new issue for AI, but I think it's just if you don't want, I'll probably treat it just like you do Google, right? If there's certain information that you don't want out there, like like the FBI is going to start sniffing if you start Googling certain interesting things, then the same thing with artificial intelligence, I treat it the same. Because you're probably going to be able to the same protection. I don't necessarily think the concern I have is like unlike Google, or I shouldn't even say necessarily unlike Google, because Google's probably using all the prompts that we use anyway. But just like Google, like I would not disclose in any form, whether it's just through any kind of internet service provider, any kind of search engine, any kind of artificial intelligence, trade secrets, personal identifiable information that you're not willing to either it's your own and you don't mind people using and disclosing, or someone else's and if you're ready to deal with the consequences, then by all means. But if you're not, I would keep that sensitive information away from those particular models.
I think it's the danger in that, like, so say for instance, you have a customer, they go and they ask the wrong question. I, as the company owner, get subpoenaed by the government saying, hey, we need that person's information. I give them that person's information, but now I'm now liable because that person can come back to me and say, hey, you gave them my information and that got me in a lot of trouble. So now I'm suing you for...
Not necessarily, because if I have the information, this is with anything, even with data privacy laws, there's always exceptions for criminal, right? There's not going to be the data, because that would be counterintuitive, right? Having a data privacy laws in place that are like, you need to keep this information private, including from the government, when they have a lawsuit and they're coming and subpoenaing it from you. Like, no, that would be contrary to public interest, right? There's an interest.
Get away with it then?
Yeah.
Well, Apple fights it in court. And so again, like if the question is over broad, right? If you're asking for example, like at Apple, there's issues like with unlocking someone's phone, right? And you want certain information on someone's phone. Well, Apple, the government come in and say a crime was committed, and right, the person who's accused of the crime, they're dead, and we can't access their phone, but they have their phone, they want to access it, and they're like, Apple, we need you to unlock it. Apple's like, no, or proof, or not necessarily no, but like you're gonna have to go to court and you're gonna have to get a judge to say we have to open this. We're gonna fight it in court. So I'm not necessarily saying that. So eventually, there's going to have to come a day of reckoning where a court, a tribunal says, Apple, you need, and if Apple will comply, Apple's not going to be, if the judge says you need to pass over and open the phone, but Apple's also going to be like, they don't need all the information on the phone. Tell us what information you need and we can pull that. We don't need to, unlocking someone's phone. And Apple, the way they're doing it is they're like, we're on the side of our consumers. We don't want to be known as soon as, the government knocks on the door, we're just like, oh yeah, we'll unlock the phone for you.
That's going to erode consumer confidence.
No, but that's a cop-out, because you're not talking about consumers, you're talking about fucking criminals.
Well, here's the problem with that. What if I just say you're a criminal?
Well, there's got to be proof. Like I'm serious. There's got to be some proof.
Yeah.
And in these cases, there's proof. You know?
Well, I'll say this. I mean, I think on the legal end, I'm not taking a position either way or the other. I think on just making the case for both sides, typically the way it goes, yeah, the government's going to come in and say this person's a criminal, right? And say, and that still needs to be proved in court.
Yeah.
But hey, this person's suspected of a crime. We need this information. Apple's of the mindset of, in most cases, from what I've seen and read, is like it's not that their position is, it's not that we're against, but they want it narrowly tailored. At least that's their argument. We want it narrowly tailored. We'll give you the information, but I know there was one case in particular where the police wanted the phone unlocked, so they could just go through the entire phone and all the data. And Apple's position was, no, because there's a lot of information on there that's not relevant to the crime.
How does Apple know that though?
Because
He
Apple
could have been communicating through secret apps and stuff. In a fucking video game, he could have been communicating with his co-conspirators.
True, but again, it's on the government to have that. The government can't just be like, because again, we have the Fourth Amendment. The Fourth Amendment protects us from unlawful searches and seizures, right? So let me give you an example. One limitation is like, let's say I am being, let's say the police get a call. Hey, there's a black guy. He's wearing an orange turtleneck with a blue suit and tan boots, right? And he wears glasses. And he is suspected of stealing, a couch from someone. Okay? And let's say someone pulls me over, I meet that description, right? Hey, let me ask you some questions. And let's say they want to do a search and they want to get a warrant. They're going to be limited to where could I be holding a couch, right? They can't necessarily search my trunk, for example, right? Is there going to be a couch? Is there reasonably going to be a couch in my trunk? Like I have a very small car. Can't fit a large, sectional couch. That's a limitation on the government. The government can't just go in and search and be like, okay, we want to search maybe they can search my house. That's probably where I could, my garage. If I have like a personal self-storage space that's large enough to hold it, sure. But does that mean they can just go through my glove box? Probably not. That's probably a little more unreasonable. So there are constraints. And again, I'm not saying Apple's doing this for good reasons or not, but Apple is basically saying, you need to show us how this is reasonable with your request. Because you're right, maybe they are. But the government should say, well, we think he was communicating through, if you're communicating through any communication means. Okay, if you want to make the argument that Apple's position is, make the argument that, okay, he's doing it through video games or whatever. But, maybe you need to go through his notes app or his social media. But, he's got some random, dog trainer app on his phone. You don't need access to that.
But maybe he was communicating through that app.
Well,
you don't know that.
But again, it's going to be, and Apple's point is, bring it to the court and make the argument that it's reasonable and let the court decide.
So my opinion on that is,
yeah.
if it is a lawful search and seizure, if there is the probable cause and there is evidence, there should be no limitations. Apple should give it up.
And that's you, and you'd be a great DA. You'd be a great district attorney.
I think you
but
have to
yeah,
be careful with that, because if I have the power to deem who's a criminal and who's not a criminal, then
that you don't have the power.
Well,
we're talking about the law and evidence with evidence.
No, I understand what you're saying, but it depends. Like, I think that the law is there for checks and balances, so it all doesn't go to one person. So, like, if that one person now deems that person, like another person, a criminal, I now have, I can do whatever I want because I've just deemed that person as a criminal. So I'm like, the fact that the discussion is happening, that's a really good thing because it's protecting our freedoms. Because the thing is, he may be a criminal, but I'm not. What I think what he's trying to say is that, it's good that those questions are being asked. So now we both are not getting stopped because he did the wrong thing. I didn't. You know what I mean? And it really just, I think you kind of see where I'm going with it. Like, it's important for the discussion to continue.
Sorry.
To be
I'll
go ahead.
wade in for a sec. So,
Yeah.
I'm a tech guy, so part of my history is I did create a pretty large social networking.
Oh yeah.
Oh, nice.
That, not really big, but big enough. It's got like 20 million people on it.
That's pretty big.
Yeah, and not that big. in the real world, it's not that big. And so I wrote the terms and conditions and the privacy policy. And the way that I did that was reviewing about 30 other people that are doing just what I'm doing and reading their stuff really carefully, and then having a great attorney whittle it down. Privacy policies are not privacy policies, they're privacy disclaimers.
Yeah.
They're to let the guy off the hook. So everyone thinks a privacy policy is a privacy policy. It's not. It's the opposite. It says, and so was an anecdote that I learned, but the other big thing that I learned was that even though that sounds like a lot of people, it's not. It was just like 3 guys, and we're trying to make a living. Which means if the government comes knocking on my door, I'm like, I don't have the money to fight anything. I don't have the wherewithal to deal with that monolith coming to get me and my livelihood. So the truth of most all of these apps is, 1, it's wide open, and 2, if the government comes knocking, you're like, but Apple's different, which is why I think what Apple's doing is really good, because they have the resources and the funds to litigate and put up firewalls.
But this is only an issue
that's my first point.
When there's fucking criminals involved.
But then
Apple's protecting criminals.
My second thing is, let's just say that my social network is for alternative lifestyle people. Just keep that really vague. A lot of people think they're criminals for doing what they're doing. So the point is the person the prosecutor that's coming in to prosecute and investigate.
So are you talking like the biohacking?
Well, I'm just saying that someone who wants to invade privacy, and let's just say it's the law and it's the government, they, of course, to their advantage, want as broad powers as they can have. Because the label of criminal is a very broad label. And so that's where I think, just in general, my opinion is that guidelines are needed, and wide open steamroller, because the government's really big, giving the government a steamroller where there's no guidelines, there's no barriers, there's no walls.
Well, there absolutely should be guidelines, but if there's a criminal case involved,
I've dealt with criminals in my life,
and you need to get more information to take down a network of criminals.
I don't know. I kind of feel like they're already doing that with the Snowden disclosure. I mean, I know you're pro law enforcement here, but I kind of feel like they're already doing that with the software and the backdoor channels they got with all the major Google and Amazon. They already have access to our information.
So I just wonder what makes Apple so special.
NSA
like why they
can here in Vegas.
Is it just because they throw enough money at the system?
Well, so I would just say this, because I'm not taking a position on it either way, but I think this is more of a criminal question, which is not my area, but I know enough about like criminal procedure to talk about it. I think for Apple, it also becomes a positioning thing, because it's like if you have our product, we are not backing down. We are going to protect your data and your privacy up until the bitter end. And
until the bitter end. But what if before that bitter end, that stupid idiot goes and blows up a building?
Yeah. Well, I think
then the protection should stop.
I think there's 2 things. Number one is, in our country, you're innocent until proven guilt. And so I think part of your analysis is, once someone's accused, you're just like, they're in this criminal box, which is contrary to the way our government is. Which I get, but I understand how you feel that way. Also, again, there's the scope of reasonableness. It sounds like in your case, it's like, using my example again, they should just be able to go through every little notebook I have look for any let's say the government needs to prove up and say, here's evidence that we have that we suspect of a crime has been committed. Then in that scenario, they are allowed to go and get certain information, but to an extent. In the scenario I'm giving, you're asking Apple to just hand over an entire phone unlocked. Apple's taking the position that there's probably information on there that is not relevant to the crime. And I see your point too. Your point is, well, maybe there is and we just won't know. But that's the whole issue. If you just allow a no holds barred, we kind of go back to the days of England, where the crown could just come in and just say, give me everything because we suspect you of a crime. Versus the Fourth Amendment gives us protections where the government has to come in and say, okay, here's what we're suspected of, here's why it's reasonable And Apple's kind of holding their feet to the fire saying, you got to prove it up. Now, you may not like that. You don't have to. But that's kind of where the law is here. Whereas there are, and I think from the business side, Apple is, and I don't think it's just Apple. I think Apple gets a lot of coverage on this, but I wouldn't be surprised if Google, Microsoft did the same thing. But I think the positioning for Apple, though, is we are going to protect your information. And so that makes people feel safe, right? Not just necessarily criminals, but I know like they're not just going to pass up my, it does. I'm not saying not just criminals, but I'm just saying people do as well.
That's got to be the difference between the USA and the CCP. In the USA and North Korea, because in North Korea, I'm like, if you're guilty, you're guilty.
Yeah,
that's it.
You're already considered a criminal. You're already labeled, which goes back to your point earlier, which is the government just labels you a criminal.
Next case.
You know, that's why we have the Fourth Amendment, so that just because you are accused of a crime, for example, in the United States, there are still protections in place that the government just doesn't have a no holds barred access to your information. There's a burden that the government needs to meet and needs to prove that the evidence that they're requesting or want access to, or the area that they want to search, that falls under is a reasonable search and seizure. And so I think what Apple's doing is they have I think, to be honest, do I really think they care about anybody's privacy? Probably not. But they care about customers, and the customers feel safe knowing if I'm with Apple, I know that my information is going to be safe and secure. It's going to be encrypted, but also if someone comes, whether it's civil or criminal, if someone comes in and tries to poke around and tries to get my information. So I think it's more of a positioning thing personally. I'm not saying whether it's right or wrong, but I just breaking down, that's the way kind of criminal procedure works.
And that makes total sense.
Yeah.
It does.
The more that technology evolves and stuff like that, the more you're going to start to see new kind of problems. Because one of the things that I've seen is that Apple came out with AirTags like not too long ago.
Oh God, yeah.
And it's just
those
like
are fucking awful.
You know, and nobody really talks about it, but I'm like, people are being like followed, robbed,
kidnapped. Yeah,
I mean,
robbed.
I personally, like, number one, when I get picked up by an Uber, it's never by my house. I'm always like a couple blocks away.
Yeah.
Right? And I purposely don't park in certain areas because I know that they can put that tag on your car and figure out where you're at.
Yeah.
And it's just like, where's the limit on that?
Yeah.
Because,
the limit should be some fucking accountability. Sorry for my language. There should be accountability. All of those tags should be registered and tracked just like a goddamn phone.
Well, I mean, one of the things that I've always argued, right, is like people talk about, like, the funniest thing is that if you lose your phone, right, what's the name? The service provider knows exactly where that phone is and they can lock that phone down, right? Why is that technology in guns? But then, take it to a whole nother level. Because I'm like, if I know that gun is not registered, like for me, if I see a laptop and it doesn't have a serial number, big deal. I'm like, I get the firmware information. I know exactly where it was and where it went and where it's going, right? If I have a gun with a serial number on it and that thing is digitally licensed, I'm like, well, what's up with the crime? I'm like, there shouldn't be any.
That's a cool idea. I never thought of that.
Of that one's really, really easy, which is to have an RFID tag in the gun.
Bingo.
It's super easy. It doesn't cost a penny, and so if you end up with a weapon without an RFID tag, so it's different than the whole serial number game.
What I love about that is that there's a reason why that's not happening.
Yeah.
You know what I mean?
Because there's too much money.
I understand. I'm like, cool.
Yeah.
I
understand, and I'm like, fuck that.
Cool. All right, now I understand how it flows. So my whole thing is not to really change the way it happens, but to understand why it happens.
But don't you want to change that? You don't want to change that?
To a degree, because you have people who are proponents of change and people who want to stop it. The old guard tends to want to stop it. The new people who are coming in, they want to see that change. And like for me, I've always been in a balance to where I understand the old guard and why they think the way they do, but I understand the young people too. So it's like I'm trying to find that nice balance where everybody's happy. And I think that's when everybody proliferates. Because, you can't just take away what's always been there. To me, I'm a big Game of Thrones fan, right? So like when I saw, the dude from the smaller family go up against like the Lannisters, and they really thought they were going to win. I'm like, that guy's been there for forever.
If you haven't watched it.
I'm like, you think that you're going to take him down and he's been doing this for generations? That's not going to happen. You know? So I'm like, honestly, if you really want to win or just have that middle ground, there's got to be balance. Yeah. Like, you have to understand both sides.
Yeah, I totally get that. That's why I think there should be major protection for consumers until they cross a fucking line. They start committing crimes and shit. They should not be considered consumers anymore. They should be considered criminals. And Apple and every corporation that can help or has information that can help catch criminals should just give it up.
And I think part of that is what it boils down to, and I think a lot of the discussion is defining who defines and what is the line that defines someone as a criminal.
Sure. Evidence. Evidence.
But
proof. Video proof.
But you become a criminal after there's a trial. So I think what we're talking about, and this is why I think you're jumping ahead. You're labeling someone a criminal, but as you said, how do you get the evidence for us to get to criminal? You have to subpoena the information. Until we get there are all these protections in place.
But isn't that what you would essentially be doing, is subpoenaing someone? Like,
but the subpoena has limits. That's the limits we're talking about. Is like, going back to the example, it has to be reasonable search and seizure. Otherwise, we're no different than old time England, where it's like, oh, we accuse you of speaking out against the king, so we're just going to take all your stuff, and then we're not going to ever give it back or tell you when. So I think, this has turned to like more of a policy conversation. But I think when in the United States, no one's just immediately labeled a criminal. Socially, we may call them that. Until you're not a criminal until there is a jury of your peers, or if you do a bench trial and you waive a jury trial, you have a trial that goes forward and says, yes, this person is, or you take a plea deal and you just accept it. You're not going to be considered a criminal. Up until that point, all the rules, that's why we have rules of evidence. That's why, like, hearsay is a thing, right? Just because I heard something from you and you heard it from him and you heard it from him, right? Well, that's 3 different layers of hearsay that's likely going to be considered unreliable. No different than the example I looked at. You're looking for me, if you're looking for evidence of me stealing a couch, there's no need for you to look through my glove box, through my wallet, and other small things where a couch can actually fit. It's likely not going to be reasonable. So there's ways to get there, but I think we took a nice turn to policy, to some larger policy talk, legal policy talk.
Awesome.
I got a question.
Yeah, for sure.
If you starting a startup,
okay,
what are some things that you think that startups should look out for?
Absolutely.
As far as it pertains to intellectual property, and copyright, and
absolutely,
and investors.
Yeah,
you got like a team of 2 or 3. You got 10 investors. You got $500,000.
Yeah.
What are some things that you think they should start from the get doing?
Like to protect the IP, the property.
Yeah.
First thing I would think about is making sure whatever business entity you're using, figure that out. And then also get that stuff in writing. I see a lot of startups where it's like, we're all friends, we don't need, so Nevada, for example. Nevada, you do not need an operating agreement to open up an LLC. You don't need one. I encourage people all the time to do it. They're like, Caleb, I don't want to spend the extra $1,500 for you to draft it up and do all that. And I tell them, you need one, because I've seen it. A couple friends from college, they all love each other, we're all cool. 5 years go by, right? Let's say, and this is how it always goes, like so-and-so is supposed to be doing the coding, so-and-so is supposed to be doing the fundraising and the operations, right? And then, they do it for the first year or 2, and then the person that's supposed to do the coding kind of like falls off, they're not doing as much, but they haven't had like no one's confronted them, but they're not really involved, they started their own thing, it's kind of like whatever, they're just doing their own thing. 5 years later, your business gets acquired, right? You all had a handshake deal that, you guys are splitting it 50-50. But my man hasn't produced any code and done anything for the corporation in the last 3 years. Now he wants his 50% cut. And you're like, well, where have you been? I've been the one building the business. And you're getting a lawsuit because of a big thing. How do we avoid that? An operating agreement. Operating agreement spells out all the rights, who has shares, right? Who gets what? What do you have to contribute before you can actually take your like whatever percentage? How does voting work? this especially happens when we have two people. You're splitting 50-50. Well, what happens if y'all disagree? You need an operating agreement that spells out this is what happens. Whether, if person A, person B, if we disagree, person A, their decision carries, person B carries, you all talk to a third party, you play rock, paper, scissors, whatever it is, you codify it in the operating agreement, and that determines what voting happens, right? If if you're doing 33%, obviously that makes it a little easier because someone's going to have like 0.1% more to make it 100%, right? What happens if someone wants to sell their percentage? Do you get a first option to buy or to get those? Can they only sell them back? Or how does that work? Can you have a first right to refuse? You need to spell all that out. That's one of the number one things they do. On the IP side, you need to think about things such as securing the trademark rights in the name, ensuring there's no one else using the name. I tell people this, I've seen this happen all the time trademark rights, a lot of people think, oh, you need a registration. Not necessarily. You start using a mark in commerce, you have rights. That's a good and bad thing. Good for you because it doesn't necessarily mean you need a registration. Registration helps, just like with copyright, helps enforce. You can get heightened damages if someone infringes if you have a registration. There's proof of you get all these presumption that you own the mark, presumption that it's valid, all these other great things. Makes it easier to enforce. But on the flip side, just like if you go out and start using a mark in commerce and you get trademark rights, someone else starts using a mark in commerce before you, they have trademark rights wherever they use it. So that means even if you come up with a name that you think is unique, right, and start using it, if someone out in Florida, out in Maine, have been using that mark and they haven't registered it, but they've been using it before you in connection with similar goods and services, right, that may be your use of it may be infringing. And I've seen a lot of people who dive in and they adopt the name and they think there's no problem with it, and they go 3-4 years, and then all of a sudden they get a lawsuit and they get a cease and desist letter, and now they have to deal with someone else who's been using the mark before them, and they're the prior user, and it's likely we go through the analysis. It's tough, and they have to go through a whole rebranding process. All that marketing, all that a goodwill you built in that name, you now have to give up and adopt a new name. So I think that's big. Another thing I say to startups, a lot of you all love going to these pitch competitions and telling everybody about your idea, but you also want to get, something that you want to get patented. So I tell people with that, you need to be careful. You go into these pitch competitions that are just getting recorded and publicized. So there's a 1-year bar on patentable ideas. So basically, patents are only good if they're novel. It's one of the requirements. Meaning there's a 1-year bar. If it's been disclosed for more than 1 year publicly, you cannot get U.S. patent on it. You're not going to be able to get it. So if you go and that's why we come up with provisional patent applications. Now you hear this like on Shark Tank all the time. They get a provisional application. They typically do it before they go on the show. It's not a patent. A provisional patent is not a patent. It gives you a 1-year it basically gives you kind of like this shield that says, from 1 year from now, I'm going to file a non-provisional patent application that can mature to a patent. A provisional just basically gives you kind of like a public lock that says, this is my idea. I want to kind of stake my flag in the sand on this idea. And then in a year, I plan on filing a non-provisional. It also gives you kind of the freedom to go out and start staring the idea. It's a lot better than if you just start relying on like the 1-year bar and you just go out and start telling everybody, and then someone can be like, oh, I came up with that idea before you, right? No, you're like, nope, I have a provisional. That's kind of like my real strong evidence of I'm the one that came up with this idea. I tell people that if you want something to stay secret, right, keep it a secret. I see a lot of people, and it's not necessarily like a general idea, like this is my general business idea. I have this app. But when you start talking about that secret sauce that you want to get patented in the future, like how our software works, we do this specific thing that's novel and unique and no one else is doing, that is what's key. And that would needs to stay confidential. And that when you go to these pitch competitions, don't share that. Because as an examining attorney, if you file a patent application, they're going to go to Google. They're not just going to go to like these fancy, spancy like search tools. They're going to go to Google, they're going to go to YouTube. Is there anyone talking about this particular idea and how they're going to look at white papers, they're going to look at research papers, They're going to look at things that are public in journal articles. They see that. They see some overlap. They see your YouTube video from 3 years ago of you talking about your idea. Your own idea will serve as what we call prior art. And I've seen it happen to many people where I'm like, you can't really patent that. And because you disclosed it, not only are patents not available, trade secrets not available, anyone can basically use and exploit this particular idea. So that's things I tell people to keep in mind. So those are some of the big things I tell people is operating agreements, being careful about disclosing patentable and trade secret subject matter, and doing a trademark clearance search at the very earliest to make sure you have free title to use a particular name that's not going to bite you in the butt with some kind of trademark infringement in the future.
Operating agreements updatable?
Yes. You can always amend. It's basically, operating agreement is basically like an agreement between you and the other owners or even like investors, right? I think LLCs are great for startups. I don't understand. There's a lot of these, like, I see folks that are just coming straight out the gate with just an idea, no proof of concept, and they want to jump to like a C Corp, an S Corp, and I'm like, why do you want to do that? They're more expensive, and there's a lot more formalities. Okay. An LLC, and also there's a tax issue, right? There's a double tax that comes with corporations, right? You're getting tax on incomes as well as whatever you're paying out. LLC is one pass-through tax. That's it. So there's that. So you want to preserve capital and all this stuff, LLC is the way to go. Where I think a lot of these startups, they get, I don't know if it's just like the sexiness of being a corporation, or it's also the issue of like, well, investors want to see S Corps and C Corps. Yeah, you can always, if you want to end up, you can wind down the LLC if you have a serious enough investor that's like, I'll only invest in you if you have a C Corp or S Corp. A lot of the investors want that because why? Because there's all of these formalities you have to go through in order to make amendments, in order to make changes. A lot of these investors, they have their own attorneys. They've been through this before. The founders are in the position where they don't have the attorneys, they don't have the money. So I like LLCs because, like you said, with the operating agreement, right? It starts off with just 100%, it's just you, and now you want to bring on another investor, and they're going to take out 20%. When you amend the operating agreement, right? Get an attorney like myself to amend it, do some back and forth negotiating, right? They're getting 20%. What are they contributing? They're making X amount of dollars in a capital investment by such and such date. We're going to put that in there as a caveat if they want to collect. Because if you sell the business and they haven't given you like $50,000 that they said, well, they don't get their 20%. And that's in the operating agreement. If they want to go litigate, you can be like, well, Your Honor, there is no breach of contract here because they never performed on their part of the operating agreement. Where's my $20,000, $30,000, $50,000 that we put here? So you can always update it. You can always amend it. You want to bring in new investors, you amend it. Now it becomes a little bit more tricky because at that point, a little different. It becomes negotiating a single document versus with C Corps, S Corps, you may have to get shareholders involved. You may have to post a public meeting. There has to be, people have to come together and there has to be a formal vote. People have proxies that vote on their behalf. All this formality stuff. LLC is just, let's amend the operating agreement, guys. Let's come to agreement. What do we want? How do we want to change voting rights? Blah, blah, blah. That becomes, in some cases, it can become more simpler. It can become complex depending on how much you want to fight. But an operating agreement, it's just like any kind of contract. And it's basically an agreement between everyone who has any kind of ownership interest in the LLC. This is how we're going to operate. That's why it's called an operating agreement. So you can always amend it. Absolutely. Okay, so to the extent you can get everyone to sign off on it, you also can put in the operating agreement like amendment rules. We all are agreeing to these forms of amendment rules. We can bring on, typically you do have that, like, that's where we have like the right of first refusal, right? It's sometimes it's not even so much an amendment. It's like, well, if I have 50% and I want to give someone else, right? Let's say I have controlling interest and I want to sell someone 10%, right? Well, sometimes there's a right of first refusal. You have to offer it to the other ones, to the other folks that they can buy up your 10% that you want to offer first. Right. If you all are already in agreement, like, yeah, we want to bring this other person on, then that's fine. But let's say someone that's like, no, I don't like that other person you're trying to bring on. I think they're bad for business. I don't like them personally, et cetera, et cetera. You have now a right of refusal to say, I'm going to buy that 10% before you can sell it off. And then it becomes a point, because now I only have so much majority share before, you could buy it all up. So now it becomes more of a strategy, but that's all things that you draft the operating agreement and then you operate from that operating agreement. And then you make amendments and you negotiate with your other members. You keep in mind who are you bringing on, right? It doesn't have to necessarily be a person, it could be an entity, right? It could be, that's where you really want to be concerned because, right, if an LLC is going to be, an LLC can be another member of another LLC, right? You can put in there that, ABC LLC is going to have a 20% interest in this particular LLC. But, right, what does their operating agreement look like? Who's doing the voting over there? They bring on someone who becomes, what if the person that you all don't like becomes the owner of that LLC, right? And now they're the ones making the decisions over there. Those are things you want to keep in mind, things you also want to put and contemplate in the operating agreement. There's all these things that you want to think about, and that's why operating agreements are extremely important.
Would you say that the operating agreement for like the beginning is probably ideal, and then I guess when you have more investors, you might want to convert that into a corporation, or just?
It all depends, right? There's no right way to form it. It's up to what you're comfortable with.
Right.
If you're comfortable with all the formalities that comes with the S corp and the C corp, and you're down with all the tax liability, and that's what everyone is interested in doing, right? And that's going to get you more money, it's going to move the business forward, then go for it. But in some cases, you may find an LLC may be the way. Now, I will say this, like an operating agreement isn't really going to be that big of a deal if it's just you. If you're a one-stop show, right, and you just want some insulation and it's just you, operating agreement probably isn't going to be, I still encourage it, but it's not going to be, right, end of the day, all those issues, I don't want to say they become non-issues, but they're not really issues because you don't have any other individuals that are taking percentages out. The voting issue isn't an issue because it's just you. You're going to make the decision. 100% of the interest is yours.
So you would say when you involve other people.
Yes, exactly. When you involve other folks, which typically is the case, you bring in somebody else. So even though you're selling equity, right? Sometimes it's not even you're not necessarily like money investors. Like someone wants to become CFO, and you're like, I can't pay you any money, but I can give you 20% of the LLC of the company, what the company's worth.
Right.
There you go. There's your share. You want to bring me on as general counsel? Okay, I want 25%. Put that in the operating agreement, right? And also spell out what am I providing you as general counsel, right? And sometimes we have tax exhibits. Here's all the things you're going to provide on this timeline, right? And you can spell it all out as deep.
Plain language.
In plain language. By this date, you're going to give me this deliverable. By this date, and that's what we literally in the contract. That's what in the operating agreement. That's what we put down. Caleb Green, gets 20% interest. This is his capital contribution. See Exhibit A. Exhibit A. Caleb Green agrees to provide, these deliverables by this date. He's going to provide us with employment agreements. By such and such date, he's going to do this. And from time to time, he'll provide, advice and counsel on miscellaneous legal stuff, right? That's all the stuff. If you end up getting acquired and I haven't provided that to you, if I want to make my claim, you're like, well, Caleb, I'm not going to give you 25%. If I try to go to court and say, well, they breached the contract, you're going to be like, no, we didn't. You were supposed to, in order for him to take on his 25%, he was supposed to deliver all these things in Exhibit A, Your Honor. He never did. And then it becomes a factual dispute about did I not or did I, right? And that's what it comes down to. But it's no longer a he said, she said, like, oh, we made a handshake deal. You now have something codified in writing that you can rely upon, right?
One of the things that I've done that really work well in startups is for every missed deliverable, they earn out by a point or two. To be very explicit.
You can put that
missed deliverable.
And it's just like any contract. You can put it in plain language, and as long as it's clear, non-ambiguous, and everybody agrees to it and it's enforceable, right? It's nothing like illegal or something against public policy. You're totally you're free to contract.
You're the very first startup attorney I've heard say all that so clearly.
Yeah.
That's friggin' awesome.
Yeah, it's a contract.
By the way, the only time you want to do a corporation is when a big money guy's coming, forcing you to fuck you.
Absolutely. Thank you. Thank you. Thank you. I don't understand startups that are just so giddy at the beginning. It baffles my mind. They're like, I want to go S-Corp Caleb immediately. And I'm like, okay, why? And they're like, well, all the companies that end up getting acquired become S-Corp. Yes, but there's a point where I think when you're first starting up, there's just so many formalities, so many tax issues, and you rely so much on, when you're at the first beginning stages, capital becomes so important and where you're putting your capital, right? As much as I love being paid as a startup attorney, I'll be very honest. My best interest is in the startup. I don't want you to have to pay me a lot of money, right? Now, that's why we do flat fees and all this stuff. If you're paying me a ton of money, that means it's money that you're not putting back into your business. It's money that you're not putting back into making what actually makes your company go, raise revenue and raise money. Now, I need to get paid for my services, but I'm not going to be out here and tell you. If I was just like a money hungry, I'd be like, yeah, let me help you do that. We'll form the S Corp and it will cost you $5,000 and this, that, and the third. But at the front, it's going to cost you more money at the end because you're going to pay me all that money, and then you have to pay taxes on. One client, they had like formed their S Corp and they had like 1 million shares, and I said, why? Why do you have 1 million shares? And you don't have a game plan on who these shares are going to, shareholders, any other individuals who are like going to invest. I agree with you. I personally think as a startup, unless you have an articulable reason why you need to be, other than like I don't want to say the fantasy, but the aspiration of you becoming acquired. Unless someone, I'm talking about big money, is like, the only way I invest in you is if we restructure into a S or a C Corp, and they're bringing enough money where it makes sense for you to make that happen, and you have enough money, and that's going to cover like help you with the taxes, help you hire tax professionals and attorneys to help you navigate the tax process, and also have an attorney like me to help you navigate all the formalities if changes need to be made. That's where you need it. Because I honestly feel like they make you do that, number one, to put you in a position where you're stuck with the formalities. And they know those. The investors are coming in, they have their own attorneys, they have their own resources, they have their own money. And they have their own experience. They know how to navigate the song and dance of dealing with shareholders.
So they're positioning you.
Yeah, I personally think it's positioning, and I think you need to be wary of that, unless the money is really right. They're going to come in and say, we'll give you $1 million and move to S Corp. By all means, I'm not going to tell you, okay, by that time I'm like, yeah, let's do it. But if someone's like, I'm only going to make like a $20,000 investment, I think you need to look at that a lot more seriously.
Right.
Again, that comes down to not so much, it's a legal issue, but it comes down to more, again, positioning themselves where investors kind of have more control over you, and they can leverage that control because they've convinced you to adopt a certain business entity, which is why I said there's no right way to do it, but there are wrong ways. There are wrong ways to do it.
Okay, that makes sense.
Another idea, and this goes from a good friend of mine. So when the transition happens, you lose your operating agreement. So you no longer have that codified legal document to discuss behavior. And the big investor kind of wants that.
Yeah.
But then the other thing to think about is the tipping point of where you lose control. Because the complexity of a corporation is all about voting rights, who has control.
Yep.
And in the beginning, with the initial investor, you probably feel okay. But then as you go to, everyone hears all this exciting round A, round B, round C. Very quickly, the tipping point hits, and you've lost all control. There's no operating agreement. They're very complicated.
Yeah.
And I've got a really good friend of mine. He ended up okay, but he began with 100%, and after $120 million from Paul Allen, he ended up with 0.5%.
Oh, wow.
Yeah.
So once you hit the tipping point, it's a whoosh.
To me, it's kind of like a record deal. Like, you get signed, you're making all this music.
360 deals, man.
Oh, this is great.
360 deals.
Wait a minute,
What does that mean?
I have so much more money on the table.
So a 360 deal came in. So you'd be like you're like a pop star. You're making music, and someone wants to be your manager, and they make you sign these 360 deals where I'll be your manager, but I get a percentage of everything that you get, not just music, any art, any commercials, any other kinds of like sponsorship deals. 360 deals.
So 360 is just like
360 means everything. Yeah, 360 deals that happens there.
Now,
But
do attorneys or Dickinson Wright, can they make claims and take percentages?
so no, we typically don't. We typically do not. I've been asked in the past about it by some people to do it personally on the side, to which we can have a conversation about. Obviously, I have to get it clear by my firm because there's like duty of loyalty there. But for the most part, our firm doesn't. Our firm's like, no, you pay us money. We do not want. They want card hard cash. So if you go through our firm, But conversations that we can have offline about percentage, that's something that's a conversation I'll entertain. If it's something like, Caleb, we want you personally, not in your capacity as an employee at Dickinson, but as another person.
Now, would you say that that's the general
we
standard?
We will edit this out of the video.
Would you say that that's the standard with attorneys and the companies they work for?
It depends. So, like I would say my firm, like they typically don't have problems. Like a lot of our folks like work at like the law firm, or like they may do something on the side for like close friends and family or whatever. And I don't think really like we have a attorney who has his own business. He has a side business where he does like clothing, whatever. So in those scenarios, probably not a big deal. Especially in a scenario like this where especially if it's like a startup where you do not have the money to pay a law firm and you're really just like, I can only pay in equity. That's a scenario where there really isn't any competition. So as an attorney, I do have to be careful because I owe a duty of loyalty to as any employee you do. You owe a duty of loyalty to your employer to not be engaged in any competitive activity. That includes like usurping opportunities where otherwise it's something where it could be brought into the firm, or generally it's something that normally is brought into like the firm process, but you just do it on your own and you collect the money that way. That scenario is a situation where you can't do it. But if it falls outside of that, it's less likely I'm breaching a fiduciary duty of loyalty. Now, some companies, you're not breaching a fiduciary duty of loyalty. Your question is, that's why it depends. If someone's employer doesn't care, yeah, go do whatever. We don't care as long as you're hitting your metrics at our job. We don't care if you go out and do a project here. Just make sure you're getting stuff done here. We don't have a problem. Then there's no breach. It all kind of depends on the inner workings of. There are some big firms that are like, absolutely not. You don't have to do any of the legal work outside of what you're doing for us. If you do it, that's a breach of. We're not going to give authorization, and we consider that a breach of fiduciary duty. So it kind of depends. I'm kind of on the side like my firm to the extent doesn't care. They're kind of like, do your work, and as long as you're getting your job done, we do not care what you do. I don't care where you do it from. I work from home all the time. We have an office here. I barely go in, probably maybe once a week, when on a good week. They don't care as long as I'm getting my work done, right? So it all depends on the firm and the attorney and what their obligations are to their employer.
How long have you been practicing law? I'm like, you look like a young guy. You're like college. I'm like, how do you? He's like, I work with this judge. And I'm like,
yeah.
How old are you?
So I'm 30. I've been practicing. I'm going to my 5th year practice, but I've been working with my firm for going on 7 years. So I started with them after my first year of law school, and I worked as a summer associate and also worked throughout the school year during my 4 years of school. So I have like 7 years of experience, but I've been officially practicing a license for going on my 5th year now. So, but a lot of it has been doing stuff like this. I got involved with Tech Alley shortly after it started, like a year and a half ago or so. I've been really engaged. I do stuff like this where I get questions. Sometimes I get questions where I'm like, I don't know the answer, and I go ask other questions. I'll talk to other attorneys. I look at other like cases and other case studies, and so that's where I've kind of been able to build my knowledge. I absolutely don't know everything, but this is kind of like the general knowledge base I've been able to build, and I continue to build on that. So, yeah, I'm a nerd. I'm a legal nerd at the end of the day, but also I'm like practical. Right, I've learned a lot about the startup space, and like I don't have a startup. I do not have an entrepreneurial bone in my body, really. Not really. I'm more of just like but I understand the business side, and I'm like, if I'm running a startup, like what makes sense? I need money going towards what's going to make me money. Right. Spending it on an attorney is like not the best move. So that's but I look at it from that standpoint. I'm like, okay, as a startup attorney, how can I keep things at a low flat fee cost? Give you kind of the basics, which is what we do. I try to provide like fractional. We're a full service firm, so I also, even though being a full service firm, we're based out of Michigan. We charge Midwestern rates, not like Western rates. I try to do everything at a flat fee, add discounts when I can. So I try to make it palatable. What makes sense for the startup owner? Because a lot of times people as attorneys, we just kind of talk and we just say, listen to us because we know better. I want to kind of empower you. As I mentioned before, I want to be a resource. I don't just want to be, Caleb told me to do this, I need to do it. I want it to be, okay, Caleb explained this to me, I understood it. I value Caleb. Even if there's stuff our firm doesn't do, or maybe our price point is just not going to work out financially, I will refer you to somebody as best I can that I know and say, talk to this person. or look at these resources, or like, you know, you can't pay, no one wants to take you up because you don't have the money, and no one wants to take equity, right? Here's some free game, here's the law, here's some resources, go read up on it, so that way you can kind of bootstrap it the best way you can. I try to give you something. That's my goal, is to be a resource. I want people, when they think about startups, intellectual property law in Nevada, I want them to think about me and be like, whether I retain him or not, I'm going to walk away with some kind of value away from it. I don't charge consultation fees for the most part. In some situations I do. Like, you know, one time someone was like, I want to walk through all my code for 2 hours. I said, okay, I have to charge you for that. If you want a 30-minute call, we're going to talk for 30 minutes, 45 minutes to answer general questions and be like, here's the resources I can kind of give you. Anything beyond that, probably we'll have to charge you a little time. But in this case, it's like a flat fee. I'll charge you a small flat fee, a consultation fee, right? Most of the time, if I do a charge, it's like $250, $500, something like that, where we can sit down for like an hour or two and actually just kind of like powwow. So it's like going to be an hour or more, then we'll do like, you know, typically an hours of my time, which is like 400 hours, $400 or $500 an hour. And sometimes I'll go over. I'm not going to like put you on a timer, but to get like a full-fledged, like we just want time.
And that's our time.
Yeah. No, I'm not going to be like, and that's our time. Thank you for coming in. Anything else will be billed by the hour. I don't do stuff like that. I want to be a resource to you. This is a dick move, and again, I'm not asking. I want to build relationships, right? I look at this as kind of a long game as well. Like, I'm in my 5th year of practice. I don't know everything. In 10, 15 years, I will be a much better lawyer than I am today. I will be charging probably a little bit more, but also startups will be a lot further along. You'll have a lot more resources, and then that's when you also can rely on me, and we don't have to do the whole flat fee thing. We can have a more beneficial structure, but I want relationships. That's what I want.
Attitude is key. Like,
yeah.
You know, I noticed just from your responses to certain things, you're very senior as far as like what you've been through, but the fact that you're sitting here and you're willing to listen to what he has to say about things that that shows a lot.
Oh yeah.
You know, that you're willing to listen and to understand what he's saying, because like I have had like 20 years of my career. There's things that he's bringing to light that make a lot of sense, and it kind of changes your perspective. You know.
Yeah. So I mean, every word is golden. Really.
Well, I'm glad. I'm glad it's helpful and a resource. So.
Does this Dickinson Wright? Do they only practice the type of law that you practice, or they
full service firm?
Okay.
Everything, but if you get a car accident and you need a personal injury attorney, still call me. I will refer you to one of my good friends who does this very well. Okay. I sent him to my mom got in a car accident. That's who I sent my mom to. So, and then if they don't, obviously other personal injury stuff, our firm doesn't do it, but I can always refer you to them, and they can take good care of you. But outside of that, basically anything else, any other legal stuff under the sun, we handle. Okay. So yeah.
That's good to know.
So yeah, by all means, any legal questions, shoot me an email. Caleb, does someone handle this? Either our firm does, and I can put you in touch with them, or I know someone else who does.
Can we connect with you on LinkedIn?
Yeah, absolutely. Okay. So if you just look it up, by all means, take any information you want. Okay. Just look up my name. You'll see same images on there. Just connect me on LinkedIn. Shoot me a message. Shoot me an email, however you like. So this is my work number. So if you need it, I do work remotely a lot. So if you do get my voicemail, I'll get it. Leave me a voicemail or just shoot me an email. And then we can set up a time to talk on my cell. So, yeah.
This was awesome.
Absolutely. Thanks for stopping by. Glad it was helpful.